Hello, everyone. This is Jennifer Tillman. Would like to welcome you to our seminar series this month. Seminar series, Caring for the Caregivers and Family Members. Let's see how many people are here. We're going to start in about a minute. Okay. So we're going to go on and get started. Again, I'm Jennifer Tillman. I am a real estate agent with Keller Williams. And our guest speaker today is Attorney Ethel Mitchell. And Attorney Mitchell will be talking about wills and trusts. And both Attorney Mitchell and I are part of the Prince George's Senior Provider Network. It's a network of businesses, nonprofits that provide services to seniors. And I provide services from the standpoint of real estate services as well as coaching services. So I work with seniors and caregivers, providing downsizing coaching services, as well as just regular life and transformational coaching. As well as real estate services for those that are looking to either sell a home or purchase a home. And so I also have created the Facebook page, Caring for the Caregivers of Prince George's County. And if you'd like to join that page, you can scan that QR code right there or do a search for Caring for the Caregivers of Prince George's County. On that page, you will always know about some of the upcoming seminars that we're going to be having. The seminars, as you probably already know, are always on the second Thursday of the month at 2 p.m. Sometimes they're in person, sometimes most of the time they're on Zoom. And before I turn it over to Ethel Mitchell, Attorney Mitchell, this is how you would get in touch with me, Jennifer Tillman, my phone number, my website. And one thing I'd like to share is coming in January, you also get this information in my newsletter. I will be doing a seminar. It will be a workshop over several weeks on listening to your life. Listening to your life so that it helps you to look at where you are right now, all of the connections that got you to where you are right now, and looking at that and deciding where your life is taking you based on just taking some time and looking at the connections and looking at where you are, your values, what purpose you have now in life. Because as we move through life, our purpose changes. So anyway, I will be sending more information on that. So today we're talking about wills and trusts, and I'm going to now stop sharing this and turn it over to our speaker today, Attorney Ethel Mitchell.
Thank you very much, Jennifer. I really appreciate it. My company is called Wills and...
One second, I'm just going to remove me.
Okay, let me know.
You can share now.
Okay. Oh, you don't see it now? Okay, in just a moment. Let me try it again.
We saw it.
Is that it?
Yes.
Okay, all right. Thank you very much, Jennifer. I really appreciate you allowing me to speak with your people. My name is Ethel Mitchell. I'm an attorney, and I founded a company called Wills and Trusts LLC, because the only kind of work we do is wills, trusts, power of attorneys, and associated documents like that. We do probate. We help people administer trust as well as create trust for them. We help them fund the trust. And generally, we tell people how they work toward making sure their legacies are exactly what they want. So this is a whole presentation that I've prepared to go over most important things with you. We have 3 attorneys in our office. Myself, I went to Columbia Law School and Fisk University. My son, attorney Ronald Scott Mitchell, he's a graduate of Yale University, Howard University Law School, and Georgetown University Law Center. And attorney Brenda Morton, who is a graduate of Georgetown University and Georgetown Law Center. As I said before, this is the only kind of work that we do. So let's talk about what are the 3 most important basic documents that every adult needs to have. You need to have a last will and testament, an advanced medical directive, and a power of attorney. And perhaps a trust. I'm not a lawyer that says everybody has to have a trust, but a trust has its benefits. And so we're going to talk about it. I'm going to explain to you what it is, how it works, and so forth. And I'm going to try and leave enough time for you to ask me questions about all of these things. So let's go forth and talk about what is a last will and testament. It is really important, if you don't do anything else, to have a will. Have a last will and testament. You cannot imagine the amount of property, the amount of money, the amount of waste that takes place because somebody dies without a will. Number 1, it identifies who you put in charge to manage your estate. You cannot imagine how much trouble, time, and expense is involved with just getting that done when you don't have a will. Okay, you have the right to designate who you want to be in charge of managing your estate, and you should do so. It allows you to also identify your family, who you're married to, or if you're not married. We've actually had wills, thank God, where a lady said she was not married because after she died, somebody showed up and said, well, no, she was really married to me, and claimed a common law marriage. Well, at least the fact that she said in her will that she was not married went a long way in convincing the judge that she was not married. And that can be really important. Little things like that are really important. It says how you want your estate to be distributed. You have a right to distribute your property just about to anybody and whoever and however you want it to be distributed to. Okay? You can say, I want to give X amount of money to somebody. I want to give this house to somebody. I want to give this property to somebody else. You have that ability to do that, and you should say that, okay? If you don't say it, the law is going to give it to who the law says should get it, and it may not be who you want, okay? So it's really, really important. The last will and testament is one of the most important legal documents that anybody can have because it speaks for you when you are dead. The courts are very, very particular about the execution of the last will and testament, not just what it says, but how it's actually executed. So, for example, a witness to a will can't get anything from that will. So if you are an heir or you intend to get something from somebody, don't sign as a witness to that will. The will has to be properly executed. It has to say the person whose will it is signed it in front of you, and then it has 2 witnesses, and both of those witnesses has to say on the face of the will that they saw you sign and that each of them signed in front of you and in front of each other. That's called the attestation clause. And if you don't have it on there, the court will reject it unless we can find the witnesses and they will swear in another affidavit that that was the case. It's really, really important to get it done and for it to be accepted to probate and distribute your assets. A will is different from a trust, it's different from a deed, it's different from any other document in that, although it has a great deal of power, it is not effective immediately. In almost all states, the will has to be admitted to probate. And then when the court accepts it as a valid will to distribute property, then you have to go through the process, usually called probate administration, of distributing the will according to law. That means paying the bills and the debts of the deceased person, paying whatever taxes there might be, and then distributing the property according to the terms of the will. It is not effective immediately. And that's a big problem for many people, in that they think that just because they have a will, or they have their mama said so and so on the will, that they immediately have access to that money, and they do not. Okay, so that is very, very important for you to know. But it is still important that you have a will. I know a lot of our parents and our grandparents would say, baby, I don't need a will. You know what I want. Everybody knows what I want. Well, I tell my clients and I tell my radio audience, blame me. Tell your mama and your daddy that the lawyer said you have to have a will, and get them to do a will. It's really, really important. Okay. Now we're going to come back and I'm going to have time to answer your questions. So let me go on with the other documents. The power of attorney is a very, very important document as well. It is only effective while you are alive, but it is very, very effective when or if you ever become incapacitated. The power of attorney is someone that you trust. You must absolutely trust the person that you give your power of attorney to, because they are supposed to protect your finances and they are supposed to protect your legal affairs. Your power of attorney, your agent that you have appointed, and your power of attorney can spend your money. Your power of attorney binds you legally. Unfortunately, I have seen them misused. I have seen a son totally mortgage his mother's house to the point where she almost lost it because she gave him her power of attorney. So you do not ever, I don't care how much you love them, don't give anybody your power of attorney if you don't trust them. If they can't manage their own money, don't give them access to your money. Because when they sign your name, because that's how the power of attorney does it, they sign your name by their name, and then they put POA behind it, you are bound by that signature. So be very careful who you give your power of attorney to. That's the second document. And one thing that's very important to know, the power of attorney dies when you die. It is no longer any good. A lot of people think that when you die, the power of attorney is still good, they can still get to your money and so on. No, the moment you die, the banks cut you off on access to your money. Okay, so the power of attorney is only good as long as the principal is alive. Once the principal dies, the power of attorney is no longer any good. The medical directive is the third document. The medical directive empowers somebody to talk to your medical doctors, to consult with them on your behalf if you're not able to make decisions about what kind of treatment you have and what kind of treatment you want or do not want. They are empowered to advocate for you and to support whatever preferences you have indicated in terms of life support and end-of-life care. So you want somebody who is hopefully physically near you, who can go to the doctor with you, who can listen to what the doctor has to say, who can help with your medical care and so forth, and be available to make the kinds of decisions for you that you would like made. When you're sick, you may not be able to do that. Quite often you're not. And so you really want to make sure that you have in place the agents in each of these three documents: your power of attorney, your medical directive, and of course you want to have your last will and testament executed properly so that your distribution of your assets can be as you wish them to be. These are your three primary documents. And not only do you want to have them done, you want to tell your agent and maybe even give them the originals of these documents. At the very least, they need to have a copy of them, and preferably they know where they are if they don't have the originals. That's really important because sometimes people die and we don't know where the originals are. And that can be very difficult. That makes life difficult. So let's talk about a trust. What is a trust? Everybody hears about a trust. You don't quite know what it is and so forth. So let me tell you what a trust is. In a trust, most of the time, and I'm talking about the most common type of trust, a trust is a legal a document that is prepared by a lawyer where you are the trustee manages the assets, and you are also the beneficiary for life. Now, that's the 90% of all trusts are like that. They're called revocable or living trusts. You can change it. You can change who the trustees are. And you, of course, designate who's going to be in charge if you become incapacitated. And then you also designate who gets your assets when you die. So that's really important. You name your own successor trustee. Okay, so you say, if I get sick, then I want somebody else to be in charge of my assets. And for those of you who are caregivers, this can probably be the most important document you can possibly have. I have so many clients who've come back to me and said, Ms. Mitchell, I'm so glad you did that trust for me and for your mom. It helped me so much to take care of her when she got sick, or him. They are able, because they manage your assets, because your trust has in it your home, your bank accounts, your assets, and so forth. I've had caregivers who were able, because they were named as successor trustees, they were able to buy new homes. They've been able to buy new apartments. They've been able to retrofit or fix the house with the different things in the bathrooms. They're able to make all the different changes that their loved ones needed with their own loved ones' money, with their own assets. One trustee right now is building a whole new section on her house to put her mother in, because her mother can no longer live in this big old house that she has where she's been living all by herself. And even with caregivers, she wants her close to her. So because the daughter, one of the daughters is the successor trustee, the mother, thank God, is able to agree to this. But even if she didn't, she still had the power to do it. She's going to be able to sell the house, build another section on her own house, take care of the mother there, use the money from that house to because she needs 24-hour care anyway, and do everything that her mother needs doing in the way in which her mother would like it to be done. And then when her mother dies, she's going to distribute the assets the way the mother has already directed her to do. So a trust can be extremely, extremely helpful. You don't have to go to court with a trust. You don't need a guardian. You don't need a conservator. You've already directed somebody to take care of you, okay? When you have a trust, that is what is so important. And one thing that we're learning and we're doing now is that we're making co-trustees. Sometimes we don't wait until somebody becomes incapacitated. We actually name the person that you want to be your co-trustee while you're perfectly fine, because you know already exactly who it is that you want to be in charge. So you just give them the power to do it. But when you do that, you don't give up your own power. Let me make that very clear. If I'm the mother and I have a son who's taking care of me, I'm still a trustee. And if he does something I don't like, I can fire him. I can just change and take him off, you know? But the reality is that you usually know who's going to be there for you. And so at least you can rest assured that that person will take good care of you, and they're empowered to do so. That's one of the best things about a trust. You don't have to have the court get involved with your business. So during your lifetime, your successor trustee or your co-trustee takes care of you. You use your assets for you. Your assets stay separate from your successor trustee. And that can be very important, because sometimes our children or our successor trustees or our co-trustees have debts. They have creditors. They may have tax liens. They may have child support judgments against them. Those judgments are not subject. Those judgments cannot be assessed against your assets as long as they are in your trust. And that's a great big difference between a trust and putting somebody else's name on their bank account. A lot of people try to say, well, I'm not going to listen to the lawyer. I'm just going to put my daughter's name on my bank account. Well, guess what? When you put your daughter's name or whoever it is on your bank account, the law says that she owns everything in your bank account, which means that her creditors can get to everything that's in your bank account. Okay? Please listen to me carefully. Don't think that you can avoid having to do this by simply putting somebody else's name on your bank account. I've seen that happen to people where somebody else comes and gets your money out for a debt that somebody else. I've also had people where they put somebody's name on their bank account that was not the best person, wasn't an honest person, and that person stole their money and just took it and went with it. And when they went to the judge about it, the judge says, well, you put their name on your bank account, and there's nothing that they will do about it. When, however, you have a trust and you name somebody as a co-trustee of your trust, those assets are clearly your money. They're not their money. And if they take your money, there's very serious criminal as well as civil consequences for defrauding or taking money from someone, because you are what we call a fiduciary. It's really, really important. And of course, all of this is private as well. Trust can also avoid probate. It works as long as you put all the assets in a trust. And that's one thing I want to emphasize here. A trust can be very helpful, but if you just sign the trust documents and you don't have a deed done to put your house into the trust, if you don't change your bank accounts into the name of the trust and so forth, we still have to go through probate to get them into the trust. So make sure that you follow the directions of your lawyer by having your deeds done, having them recorded, having your non-retirement bank accounts in the name of the trust, which is your name as trustee of your trust. If you do all of that, then all that is in the trust already. We don't have to go through probate. Your trustee can pay your final bills, pay your taxes, if any, and move forward with distributing property, as you have said. If you have property in other states and we've done the deed into the trust, we just do another deed and transfer that property as your trust has directed. It's really, really good and much easier. It also allows you to create what we call trust within trust. And by that, I mean, for example, maybe you have some grandchildren, or you have a sick spouse, or you have a relative or a friend. You can say, when I die, take X amount of money. It could be all, it could be part, it could be $50,000 or whatever part you want, and hold that in a separate trust for the benefit of this person. So let's say you have a disabled child. You say, I want you to, when I die, create a separate trust for my disabled child. Take this amount of money, it could either be a certain amount, it could be a percentage, whatever you want, and put it in a separate, if it's disabled, it could be a special needs trust, so that if that person is already receiving or will need to receive government assistance, they can continue to receive that assistance, but the money that you have put aside for them will still be available for their care. You can hold money for, if you have grandchildren, you want it to go for their education, you can say, okay, take X amount of money, put it into a trust for my grandchildren or my children. It can hold property for generation and distribute to the next generation. So there's so much that you can do with a trust that is worth looking into. So give us a call, know your rights, learn what options you have, do what's best to you, what's best for you. Speak to a lawyer that does wills and trusts, okay? I don't do criminal work, so I would not dare to give you advice about criminal work. So please try and find a lawyer that does wills and trusts and estate planning. This is your legacy. This is our phone number, 844-952-WILL. Our website is willsandtrusts.net. Every Saturday morning, I'm on the radio on WOL with Law Talk with Ethel Mitchell from 8:30 to 10 o'clock. You can listen to me over our website, WOLDCnews.com, willsandtrusts.net. Alexa will play WOL for you during that time over WOL 1450 AM, and it's also on 95.9 FM. I'm going to stop right now and be available for any questions that you all might have. Okay.
Thank you, Attorney Mitchell. would you like them to see your podcast? Because Debbie can now share that screen.
Oh, that would be great if she has it up. That would be very nice. Yeah, we have created many podcasts from the radio shows. I've been doing the radio show for like 11 years now. But if you go to our website, you see, there's an area called podcasts. When it's live, you can click on that and you can listen to it. But there are also over 60 podcasts that are on that website, which are from the radio show itself. Okay. So definitely you can definitely, and the radio, the website has a lot of information in it as well. Our frequently asked questions are, answer a lot of questions about what's a will, what's a trust, how do they work, what's probate, what's trust administration, and so forth. So please take advantage of it because that's available 24/7. There's a contact sheet at the bottom of each page, and it gives you the information about where you can just sign up, send us an email, a quick email with your email address and your telephone number, and we'll contact you and schedule a free consultation. Okay. So does anyone have any questions? I'm sure somebody has some questions about something.
Yes, yes. All right, so if you have a question, you can either come off mute or you can put it in the chat and we will take your questions. Attorney Mitchell will take your questions. Any questions or comments, anything that you'd like to share?
Hello, Miss Attorney Mitchell. My name is Yvonne Freeland. Thank you for your time.
Sure.
My question is the cost for the average cost to set up wills or a trust with you.
What we do is this. We have a free consultation with you first, and we find out what it is that you need, what you want, what you need, what your assets are, how they're to be distributed. Do you have young children or someone that you need to take care of? We make a decision or we make a recommendation as to whether you need to have a trust or a will. And then we give you a cost of what that will be. Off the top of my head, we don't give out, exact amounts right now, not knowing anything about it. But we give you a free consultation of about 15-20 minutes just to get some basic information, find out what you are mostly concerned about, and how we can deal with that. Because sometimes a will is enough, sometimes a trust is enough. It just depends. A trust is going to be more expensive, it will, but then it does a lot more too. Okay. So it really does depend. Okay.
Yeah, we had another question, which maybe you've answered it, but it's what determines whether a will or a trust is better?
It depends on so many different things, Jennifer, and it's a good question. Don't get me wrong. It depends on several things. Number one, if you have property that's going to adults and it's going outright, okay, you don't need to hold it for any reason. You don't have anyone who is disabled. You don't have any minors that's going to get your property. You don't have any reason to stretch it out for any period of time. A will might be quite sufficient, okay? Because a will distributes everything outright. It doesn't hold it for any period of time. On the other hand, if you have minor children or grandchildren or beneficiaries that you need the property held for, if you have somebody who has a drug addiction, an alcohol addiction, or something like somebody needs to be taken care of, a trust will be more effective. Okay. It isn't so much about how much money you have as what you need done with what property you have. Okay. Yeah. And it depends on, some people have had really bad experiences with probate. Some people say, I don't want my children going through that, at all, ever again, I'll do a trust to try and avoid probate. So it really depends on your particular circumstance. We will do either one. Even if we do a will, if there's a way to also make it easier on the family with just a will, even though we may have to do probate, we'll still do everything else that we can to make it simple. But it really depends on the type of property and what you want done with it, what's important.
Mm-hmm.
Yeah.
And then you also mentioned the timing of probate, because it could stretch out, over months and years. So
Yeah.
even if you don't have property, but if there's funds that need to be dispersed or whatever, probably, doing the trust if time is an issue. I know you mentioned that, yeah.
Probate is slow. I don't care how you cut it. Probate is extremely slow. It's tedious. You're at the mercy of the court. The courts are overworked. They really are. They're very slow. They're very particular. Some courts are better than others, but still, anytime you're at the mercy of the court, you can only do so much. And it takes them time to get through the whole process of, one, just appointing somebody, and two, once they're appointed, then you have to go through the whole process. When you have a will, for example, and you file your documents, first the court has to appoint you as personal representative, okay? Once you're appointed as person, that can take months sometimes. Anyway, I won't get into that. Once you're appointed, then you have to get an EIN number and open an estate account. An estate account, then you have to go to all the other bank accounts where the deceased person had money and put that money into that one estate account. At that point, and there's also a notice that goes in the paper that says this person died. You have to wait 6 months for any creditor to come forth and file their claim. Now you have to pay the debts of the deceased person either way, okay? But it is often not wise to pay when you're in a probate unless you're absolutely certain that there's more than enough money to pay the debts before you start making any kind of distribution, okay? And then after the 6-month period is up, the claims are done, then you do an accounting, which in Maryland and in other states, you have to get approved by the auditors. When approved by the auditors, then it's approved by the court, and then you make distribution. You're talking a year before anything gets distributed.
Yeah.
When you're lucky.
Yes.
Yes.
Any other questions for Attorney Mitchell right now? Or comments?
Hello, Jennifer. This is Carol. How are you?
Hi, Carol. I'm good.
That's good. Thank you, Attorney Mitchell. Just a quick question. I'm not certain if I missed this or if it comes into play, but what is the difference between revocable and irrevocable trust, and what's the disadvantage of the irrevocable trust?
Let me answer the first one, the last one. An irrevocable trust is usually one where you give up control of your assets. In other words, in the slides I showed you where you are the trustee and your assets go in the trust and you are the beneficiary. That means that you can buy, sell, do whatever you want to with your own assets. In an irrevocable trust, you are not the trustee. Somebody else is given control of your assets, okay? They're still for your benefit, but you cannot own them yourself. There can be benefits to that, particularly when you're worried about either receiving SSI, Medicaid, or you're worried about qualifying for certain kind of benefits and so forth. That's one of the mechanisms that's used to do that. You say, I'm going to do a trust, but I'm going to give my child, my adult child, they're going to be the trustee of the trust, and I can't change it anymore. I can't make any changes to it. I can't sell it. I can't do anything else with it. They're going to be in control of it. And there's some definite uses for that, but not everybody wants to do that. And even when you do that, usually there's what's called the 5-year look back period. So you have to do it like 5 years ahead of time before you start to apply for benefits. But those there are some benefits, but there are also some drawbacks, and not everybody wants to do that.
Thank
Okay.
you.
We have another question. If a will was created in one state and now the person has moved to a different state, for instance, they lived outside of Maryland, they did their will, now they're in Maryland, do they need a new will?
Not usually. It's probably wise to go to a lawyer in Maryland just to be sure. But the full faith and credit clause of the United States Constitution says that if a document is valid in one state, it is to be respected in any other state in the union, okay? So by and large, it is valid, but it's probably not a bad idea to go to a lawyer and just let them take a look at it and make sure it's the terms of the will and the execution of the will that's so important. And a lot of times when we review documents, things have changed. You know, people have died, people who, you know, children have grown up. So it's probably wise to have it reviewed anyway. I tell my clients after 5 years at least, for sure, just let somebody look at your will or your trust, you know, see if there are changes. A lot of times people will come to me and they say, well, Miss Mitchell, all I want to do is change the name of the trustee. And I'm like, okay, but while we're doing this, why don't we look at the terms of the trust? And almost invariably, we find that, oh, things have changed. I've made provisions to pay. I just did one where the lady had said to pay $10,000 to her church in her trust, but she had also made provisions for the money to come out of her retirement account for the same church. And she's like, oh, no, I don't want that. I made other provisions for them in my retirement account. So I said, okay, we need to take that out. And, you know, as we went down the terms of the trust, there were several changes that, you know, things had changed, life had changed. And so it's probably a good idea to have those kinds of things reviewed to make sure. Yeah.
And then we have another question. I missed this one. Is an executor always needed, especially if you have adult children?
Oh, yeah. Those adult children will fuss and fight and carry on once you're dead and gone. You'd be surprised how people act once their parents are dead. It's really important. No, seriously, I've had so many cases where everybody will say, yeah, we know you're the one that mama always had to do her business, but, you know, and often it's not just the children, it's the spouses of the children that get involved, and they don't like how you did this, and mama said this, and daddy did this, and so on. Please have a will and make it really clear who's in charge and how you want things to go. So whether they like it or not, it goes that way. That's important, really. And blame me, please. Tell your mom what the lawyer said. The lawyer said that you really do need this. You really do. We've had so many cases like that. Yeah.
Yes. So we have another one. Do you need a living trust if you have a power of attorney? So I guess just sharing the difference between the power of attorney, because that's going to end when the person passes. But go on. And
it's no good once you die, period. What you may be getting mixed up with is, and I don't know why they call it this, there's the living will, which has to do with medicine. That's medical. That's whether you want to be alive, whether you want life support or not. Okay. A living trust is a revocable trust is a trust that you can change, you know, as long as you're alive and you're competent to do so. So those are two very, very different things. And you do need to have both. If you're going to have a trust, another thing too, if you have a trust, you also need a will. A lot of people don't realize that. Don't buy these packages online that say you just have a trust and you don't need a will. You do need a will even with a trust, because you need something that if you don't have everything in your trust, and when I say in your trust, I don't mean referred to in the trust. I don't mean in the schedule of the trust. I mean the title to the deed, the title to the bank accounts are actually in the name of the trust. If you don't have that for anything, you need a will, a special kind of will. It's called a pour-over will. And all that will says is, when I die, whatever I didn't put in my trust, put it into my trust. And that has saved so many different estates, because even though we have to do a probate, then we can at least get things into the trust. Okay. I had a lady come to me years ago. She had done, I won't even name the name of the company, but she had done one of these wills that trust that she got online, and she didn't do a will. And her daughter had been right there with her for her, you know, while she was sick and everything. She hadn't heard from her son in years. She died. They called me. I said, well, where's the will? There was no will. Of course, the son showed up after the mama died. There was no way to keep that house from going to both of them because she didn't have a will. There was no way to get it into the trust. And under the law, see, when you don't have a will, the law has a will for you. It's called the law of intestacy. And every state has a law of intestacy. If you remember, it's the last will and testament. So when you die without a will and testament, there's a law called the law of intestate succession. And that says how your property goes if you haven't said it. And that says if you have 2 children, they share equally. If you are married and you have no children, in many instances, now Maryland just recently changed this, your spouse gets everything. In many states, if you are married and you have no children, your parent will inherit with your spouse. You see, it's not what you might think it to be. And so you have the right to do a will, so please do it. Please do it.
All right. I think we've answered most of the questions. Does anyone have any other questions? We still have a couple, we still have some time or comments. Okay.
Okay, Attorney Mitchell, if you don't have property, but you do have, my husband and I have no debt. We do have 2 cars. We are renting. We do have life insurance policies and bank accounts. I still need to do a will.
It's wise to do one, yes. Well, but not just do a will, not just do a will. Number one, make sure you have beneficiary designations on all of your accounts.
Yes.
Not just primary, but contingent. So you want to say, if you want your husband to be your primary, or if you're on both of you are on all your accounts,
Yes.
who's going to get it when he dies? If he dies after you, okay? And then print out that beneficiary designation. Don't depend on it being in electronic form. When you have life insurance, retirement accounts, print out the actual beneficiary designation. And I say print it out because they shut down your electronic access to those things when you die. And God only knows how they know, but some kind of way they know when you die. And
Yes,
you can't get into them anymore. So print all of that stuff out, okay? It is worth it for you to have a will just in case something happens. It really is. Don't, because your husband might find out that he all of a sudden owned your house with your mom and your daddy, and that might not work out too well. I've actually had that to happen, okay? Or sometimes people show up that were children of, usually it's the man, because the woman knows if it's their child, but
right.
somebody will show up and then all of a sudden you find out your husband had a child and you got to share half your property with that child. I've had that to happen too. So why take a chance? And for that matter, if you don't have any debt on your car, that's wonderful. In DC and Maryland, there's a form that you can get from was it DMV?
Yes.
It says who gets your car when you die, even. Okay.
Okay.
It's worth it we give all of our clients a 3-ring binder with the sleeves, where you can put paper in the sleeves and stuff. And we put their will, their power of attorney, their medical directive, their beneficiary designations, one statement from every bank account they have, their life insurance, everything in one place. Because you're already sad when somebody dies. Just straighten it out and be done with it. You know what I mean? It's worth it because usually people have a lot of money and they don't realize it. You have a lot of money, a lot of assets, so protect it.
Thank you.
Attorney Mitchell, can a trust be challenged?
It can, in law, you never say never, okay? But it's a lot harder, I think, at least, to challenge a trust than it is to challenge a will. Partly because usually a trust is done while somebody is in fairly good shape to understand what's going on and so forth like that. I'm not saying it can't be. A will, you can challenge by saying that, the person wasn't in their right mind and so on like that. But usually a trust is done and then you have that trust for a while before the person dies. You see what I mean? So that
Right, right, it's already done, yeah.
you have the will, you have the, the whole set of documents and so forth like that.
Mhm.
I'm not gonna say that it can't because, anything can happen, but it's a little bit harder, usually,
Mhm.
okay?
And then I've seen or heard when it's stated pay on death, like either the house goes to, pay on, is that part of the trust when it's like paid on death? You set up something that says pay on death?
No, what the trust would say is when I die, deed this property to so-and-so. It's
Okay,
kind of,
okay, so that's part of the trust, yeah.
yeah, that can be in the trust, yeah.
Okay, so we have another question. You're in DC and Maryland. Oh, they just wanted to know if you're licensed in Maryland, DC, but they were also asking if you have colleagues or someone who's licensed in Illinois.
I do not know. We are in, I'm in DC, Maryland, and Virginia.
Mm-hmm.
Um, no, and I have been looking for a estate planning lawyer in Illinois. So if they find somebody, let me know.
Okay, okay,
Seriously, Yeah,
yeah,
seriously.
yeah, okay. Any other questions right now?
Let me say one more thing to the young lady that called and said that she and her husband um, have no debt. One of
Oh,
the issues that comes up now, I'm not saying that you have all this money, okay, but if you do have more than $5 million in assets, you may want to do some estate planning for tax purposes, okay, because there are in Maryland, there's a $5 million estate tax exemption amount. In DC, it's 4.7 million. In Virginia, it's 13 million. All of this is going to change next year, okay? But once you start getting up in those levels, and it includes business assets, retirement assets, life insurance, the whole 9 yards, you add all those assets together, and there's a certain level under which you don't have to worry about taxes. There are ways of making sure that it goes from one person to another if they're married, and they have what's called a marital deduction, is unlimited marital deduction. So there are different kinds of tax benefits to spouses that you might want to look into if you start to get to that level of income, okay, of asset. It's not just income, it's assets, total assets. So you should be aware of that, okay?
mhm.
Be aware.
Okay.
Mhm.
All right. Any other last questions for Attorney Mitchell? Okay. Well, it's
Thank
okay.
you
One
so
more,
much.
one more. Do I just call? Okay, they just want to know, should they call to make an appointment? And I don't know if Debbie has any slides to put your number back on. Okay. So this is the number to call to make appointments, Attorney Mitchell?
Yes, 844-952-WILL or 9455. And tell Miss Martin that you heard me on Miss Tillman's program.
Seminar. Yeah.
Really. Thank you very much. And we'll be glad to schedule a initial consultation with one of our lawyers, with myself, my son, or Brenda Morton, and we can get started. Okay, we can get started very much.
Well, thank you again, Attorney Mitchell. And it's always a great, time to spend with you because there's so much information that we need to know. And you are so passionate about sharing this information and making sure people know. So I do thank you. And of course, we'll have you again next several months out. But thank you. And if everyone, wants to just continue to be on our newsletter list so that you know what's coming up, please check in with me. Let's see, I don't think, was there one other question? No, that wasn't another question. I'm going to just put my phone number again in the chat. And if anyone has a question, or would like to get on our list, please do so. All right, well, you guys have a great rest of the evening. We are taping this, so it will be on my YouTube page at some point. And I look forward to seeing you guys at the next seminar. Thank you again.
Thank you.
Thank you, Jennifer. Thank you, Attorney Mitchell.
Thank you, Attorney Mitchell.
Yeah.
Yeah.
Bye-bye.
Bye-bye.